Thank you for taking the time to watch this webinar on Section 504 plans. We hope that you find it useful. My name is Stephanie Klitsch, and I am an attorney with the Education Law Program at Council for Children's Rights. Just a note that the information we are providing today is for educational purposes and is not legal advice. Before I jump into the content for this webinar, I wanted to share a little information about the Education Law Program. The Education Law Program has four main focuses. First, through our education advocacy for individual families, we provide individual representation for students and their legal guardians in need of legal assistance regarding special education, Section 504 plans, and school discipline. Families interested in legal representation can contact our Get Help email address or call 704-943-9609 for assistance. Second, through our Education Navigation Service, we work with students involved in the juvenile court system in Mecklenburg County. The service addresses issues related to students' education rights by identifying current education issues and providing detailed recommendations for how to resolve those concerns. Referrals can be made through our ELP email address or by calling 704-943-9611. Third, we focus on systemic education issues. We cannot individually serve all students in our community who may need our services. Instead, we strategically elevate issues that can have a broader impact on students in the community. Lastly, we provide free community trainings on topics related to education advocacy. In addition to our First Wednesday series, we provide training to parent groups and community groups by request. Here is the agenda for this webinar. I will go over some preliminary information and then focus on our main topic, Section 504 plans. First, I'll go over two quick notes, then I'll give an overview of the different type of education interventions. Then I'll jump into understanding Section 504, obtaining a Section 504 plan, determining accommodations and modifications, school discipline under Section 504, and filing a grievance. Before I get started, I want to go over a few terms that I will use throughout the presentation. There are many acronyms when we discuss special education and some different terms that mean the same thing. I want you to understand that students who receive special education have an Individualized Education Program, an IEP. They are also called exceptional children, EC. EC is a North Carolina specific term. Ultimately, when we are talking about EC services, IEP services, or special education, we are talking about the same services and can use these terms interchangeably. As you will learn in this presentation, Section 504 does not fall under the special education category. Some families choose to send their students to charter schools instead of a typical public school district. Charter schools are public schools authorized by the State Board of Education and operated by independent nonprofit boards of directors. Everything that I will discuss in this training applies to charter schools as well as traditional public school districts. Charter schools must follow special education law, Section 504 law, and North Carolina law on school discipline. Too often we learn of situations where charter schools are telling families that they do not need to comply with these laws. So we want to make it clear that students have the same rights in charter schools as they do in public school districts. Next, I'm going to do a brief overview of the different types of education interventions. We like to begin trainings with these slides so that everyone is aware of what we mean when we talk about terms like IEP and Section 504 plan. This graphic helps us take a step back and understand what types of services are available to different groups of students. The largest circle incorporates all students, whether or not they have a disability. Any student who is struggling academically or behaviorally in school can receive extra assistance. In North Carolina, this is through something called Multi-Tiered System of Support, MTSS. You do not need a disability in order to receive support through MTSS. In order to fall into either of the two smaller circles, a student must have a qualifying disability. The bigger of the two circles is Section 504. As we will learn, more students with disabilities fall under Section 504 than under special education. Special education is the smallest circle because it has the most stringent eligibility requirements. As I mentioned, MTSS is available to any student whether or not they have a disability. It is intended to provide extra support and interventions to students with additional needs. MTSS involves different tiers of support. All students are considered on Tier 1 and have access to high-quality instruction. At Tier 2, students with identified academic or behavioral needs receive some small group intervention. Tier 3 is the highest tier of MTSS. At this tier, students receive more intensive, individualized supports. A key component of MTSS is universal screening. This is intended to identify students who need supplemental support. By the time students get to Tier 3, they should be receiving evidence-based interventions to respond to their specific needs. Progress monitoring is a part of MTSS as well. This means that there are specific goals that the interventions are intended to address, and data is regularly collected to determine whether students are making progress towards those goals. Families need to be aware when their student is on a Tier 2 or Tier 3 plan and actively participate in the process. There are generally meetings to review the student's progress, and the family should attend and ask to get regular updates based on the progress monitoring. The MTSS team can make a referral to special education if they believe that the student may qualify for an IEP. Let's talk briefly now about who qualifies for special education services, which was the smallest circle in the graph. For a student to receive special education services, the student must meet all of the following criteria: be between the ages of 3 and 21, meet the criteria for at least one of 14 disability eligibility categories. In North Carolina, each eligibility category has specific requirements that must be shown for the student to fall under that category. For instance, a diagnosis of autism by itself does not necessarily mean that a student will automatically be eligible under the autism eligibility category. Have a disability that adversely affects their educational performance and requires specially designed instruction. I want to point out that educational performance is broader than academic performance. A student can be advancing from grade to grade and have passing scores in their classes and still be eligible. Educational performance also includes things like their social interactions and behavioral needs. Here's a list of all 14 disability eligibility categories in North Carolina. IEP stands for Individualized Education Program. The P in IEP stands for program and not plan. And that is because an IEP incorporates all of the special education services that a student receives. The IEP document itself is long, generally at least 15 pages, and is very detailed. Included in the IEP document are the student's strengths, weaknesses, and needs, measurable goals for the student to achieve in the course of a year, the accommodations and modifications, related services, and specially designed instruction necessary to help the student reach their IEP goals, where those services will be provided. This does not mean the actual location, such as Myers Park High School versus West Charlotte High School. Instead, this refers to whether the student will receive the services with their non-disabled peers, or instead in a setting with only other students with disabilities. For many students, it ends up being a combination of those options. The IEP document is developed by an IEP team, which must include the special education decision maker. All special education students are entitled to something called a free appropriate public education, FAPE. FAPE is a legal standard that requires all students' IEPs to be sufficient for the student to achieve reasonable educational progress. We often receive questions about the difference between IEPs and Section 504 plans. As I have said, all students who receive special education services have an IEP. Students with IEPs receive some amount of specially designed instruction with a special education teacher. Specially designed instruction is adapting the content, methodology, or delivery of instruction to meet the unique needs of a student that results from the student's disability. Section 504 accommodation plans, however, are for students with disabilities whose needs do not rise to the level of requiring specially designed instruction from a special education teacher. These students receive all of their instruction in a regular education environment. They receive accommodations and modifications that their general education teacher can implement to allow the student to have access to their education. Also, Section 504 has a broader definition of disability, so more students qualify under Section 504 than qualify for special education. This is why the Section 504 circle in the graphic was bigger than the special education circle. If a student has an IEP, they do not require a Section 504 plan because everything that would be on the Section 504 plan would be incorporated into the IEP. We will go into more depth in this presentation about Section 504. Hopefully an example will help illustrate the difference between an IEP and a Section 504 plan. Sam meets eligibility criteria as a student with a specific learning disability. His IEP provides services with a special education teacher several times a week to address his individual goals in reading, writing, math, and organization. He also receives modified assignments, extended time on tests, and takes tests in a room with fewer students. On the other hand, Aaron has severe myopia, which is nearsightedness. Her Section 504 plan requires seating near the teacher and board and all printed materials presented in a larger font. As you can see, Aaron does not have any special education services or any individual goals like Sam has. Also, Sam receives accommodations and modifications that, if those were all he needed, could be on a Section 504 plan. Those accommodations and modifications are modified assignments, extended time on tests, and taking tests in a separate setting. Here are some important similarities between IEPs and Section 504 plans. They both generally have review meetings every year. IEPs are required to be reviewed annually, and while that requirement is not in the law for Section 504 plans, it is a common practice for them to be reviewed annually as well. These are very important meetings for families to attend. While there is only one meeting required each year, families can request an IEP meeting or Section 504 meeting at any time during the school year. Lastly, IEP teams and Section 504 teams can spend hours and hours drafting a beautiful document. But if it is not actually implemented, then it is worthless. It is critical for families to follow up with the teachers to make sure that the services, accommodations, and modifications are actually being provided as written. The remainder of the webinar will focus on Section 504 plans. When I refer to Section 504, I'm referring to a part of the law called the Rehabilitation Act of 1973. Section 504 is a federal law prohibiting recipients of federal funds from discriminating based on disability. All public schools receive federal money, so Section 504 applies to all public school districts and charter schools. The relevant text of Section 504 states, "No otherwise qualified individual with a disability shall, solely by reason of his or her disability, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance." The definition of disability under Section 504 is different than under special education law. Section 504 protects three different categories of students. First, students who have a physical or mental impairment that substantially limits a major life activity. An example would be a student with a visual impairment who cannot read regular print even with glasses. That student is substantially limited in the major life activity of seeing. The second group are students who have a record of having a disability. An example would be a student who outgrew severe childhood asthma. The third group are students regarded as having a disability. For example, a teacher may assume that a student with facial disfigurement must also have an underlying disability. All three groups of students are protected from disability discrimination under Section 504, but the second two groups of students likely do not need an accommodation plan. We will discuss this more in detail a bit later on. Students who qualify under Section 504 are entitled to a free appropriate public education, a FAPE. Section 504 states that FAPE is the provision of services designed to meet the student's individual educational needs as adequately as the needs of non-disabled students. This analysis involves the comparison between the student with a disability and non-disabled students. Typically, the Section 504 team includes the parents or legal guardian, the Section 504 coordinator. Schools choose this person. In Charlotte-Mecklenburg schools, CMS, usually the school counselor serves as the school's Section 504 coordinator. The principal or another school administrator, other staff knowledgeable about the student, such as one of the student's teachers. Unlike with IEPs, the law for Section 504 does not specify who is required to be part of the Section 504 team. The law does specify that the Section 504 team must include a group of people knowledgeable about the student, the meaning of evaluation data, and the available services. A Section 504 plan allows a student to receive accommodations and modifications, including, but not limited to, extended test time, preferential seating, and assignment modification. We will discuss accommodations and modifications in more detail in a few slides. At the beginning of the presentation, I discussed how the IEP document is generally very long and includes a lot of different information about the student and the student's goals. A Section 504 plan looks very different than an IEP and is much shorter. It generally provides what the student's qualifying disability is and what accommodations and modifications the student will receive. A Section 504 plan does not get the student access to specially designed instruction or a continuum of special education placements. Only an IEP can secure these. I've reviewed what Section 504 is, who it protects, and what a Section 504 plan is. Now I will discuss the process of receiving a Section 504 plan and advocating for its contents. The first thing that is important to note is that not all students who are covered by Section 504 actually require a Section 504 plan. There are students who are protected from the law, protected under the law from discrimination just by nature of them having a record of having a disability or being regarded as having a disability. These students need to be free from discrimination, but they do not require accommodations and modifications. To qualify for a Section 504 plan, the Section 504 team must determine, first, whether a physical or mental impairment exists. This is interpreted quite broadly. Basically, any diagnosis is going to fall under a physical or mental impairment. Section 504 has a much broader definition of disability than special education law. Second, the impairment must substantially limit a bodily function or major life activity. This is also interpreted quite broadly. We have listed some examples here, such as walking, breathing, hearing, reading, learning, performing manual tasks, concentrating, or caring for oneself. Lastly, and this is the most important one, the student must need accommodations, modifications, services, or supports to benefit from their education at a level similar to non-disabled peers. This is where you have to show that the impairment causes the student to need some accommodations or modifications so that the student can have access to their education. We note here that mitigating measures may be considered when determining if these are needed. Mitigating measures are things like medications, medical supplies, and hearing aids. Let's think through these requirements with the example of attention deficit hyperactivity disorder, ADHD. Does a student with ADHD have a physical or mental impairment? Yes. Does the ADHD substantially limit a major life activity? Yes. For example, concentrating and learning. Does the student need accommodations or modifications to benefit at a level similar to non-disabled peers? This depends. Students with ADHD run the gambit. Some require special education services. Some can manage with accommodations and modifications. For other students, however, their ADHD is managed so well with medication that they may not need any accommodations or modifications, and therefore would not qualify for a Section 504 plan. Over the years, we have seen districts be much more stringent about these qualifying factors, so it is important to be prepared to talk about how the impairment is preventing the student from benefiting from their education at a level similar to non-disabled peers. A Section 504 plan request needs to be made in writing. We always stress that every communication with the school should be put in writing, but especially so when requesting an evaluation or services. If you have documentation of the student's disability, that should be included with the request. It makes the process much more efficient. The request should be sent to the school's Section 504 coordinator. The parent or legal guardian should keep a copy of the request for their records. Once the request has been received, the school will schedule an eligibility determination meeting. This process does not have a set timeline. A reasonable time standard applies. The expectation is that within a couple weeks of making the request, you should be having the meeting. The Section 504 team will meet to discuss whether the student has a disability that substantially limits a major life activity or bodily function to determine if the student is eligible under Section 504. If more information is needed, the team may seek the parent or legal guardian's consent to conduct appropriate evaluations. Unlike with special education, there's not a list of required evaluations to find the student eligible, but there does need to be evidence of the impairment and how it impacts the student. The parent or legal guardian may already have that information from the doctor and have submitted it with the request. If more information is still needed, the team may conduct additional evaluations, and the parent or legal guardian has to consent to these evaluations before they can be done. Once the student is deemed eligible, the Section 504 team will discuss what accommodations and or modifications are necessary to meet the student's needs. Throughout the previous sections, I have referred to accommodations and modifications a lot, and we will now discuss them in more detail. They're really the heart of the Section 504 plan, so let's discuss their purpose and some examples. Accommodations change how information is presented to a student, whereas modifications change what the student is expected to learn. The purpose of accommodations and modifications is to provide a student equal access to their education. Another way we say this is to level the playing field. The accommodations and modifications should allow a student with a disability to be fully included in the educational setting. Accommodations and modifications allow students with disabilities to do things like the following: manage a medical condition. A student with cancer may need frequent breaks due to fatigue. Access their learning environment. A student who uses a wheelchair may need extra time between classes and access to the elevator. Participate in class activities. A student with a behavioral disability may need a behavioral intervention plan to appropriately participate in whole class activities. Demonstrate their level of mastery of concepts. A student with ADHD may need extended time on tests to fully demonstrate what they know. As mentioned earlier, Section 504 plans are not long. The Section 504 plan should specifically state what accommodations and modifications will be provided and how they will be implemented. I've included some additional examples of accommodations and modifications: headphones to muffle noise, simplified instructions, oral and written directions, critical vocabulary lists for content material, shortened homework or classwork assignments, pencil grips, visual schedule, seating close to the teacher, more frequent and immediate reinforcement. There is no set list for accommodations and modifications, though some are used more commonly than others. If you are requesting something that is less common, it may help to come prepared with support from your student's doctor or other medical provider to explain why this is necessary for the student. Section 504 plans are generally reviewed once a year. This is not required by law, but is common practice by school districts. However, parents or legal guardians may request a meeting at any time throughout the year. Remember, the parent or legal guardian should request the Section 504 meeting in writing to the school's Section 504 coordinator. Also, like IEPs, Section 504 eligibility must be periodically reviewed, generally every 3 years. I like to provide some advocacy tips for Section 504 meetings. Most importantly, it's critical for the parent or legal guardian to come prepared to talk about what accommodations and modification the student needs and why. There are many resources available online with ideas for disability-specific accommodations and modifications. We really encourage preparing for the meeting with accommodations and modification suggestions. School staff may need your encouragement to be creative. Parents and legal guardians should know about the student's progress and be prepared to talk about why the accommodation or modification you're requesting is necessary for the student to benefit from their education similarly to non-disabled peers. The other tip I want to point out is that any testing accommodations must be in place for at least 30 calendar days before state testing in order to use that accommodation on the test. In this section, I will discuss special protections in place for students with disabilities when it comes to school discipline. These provisions apply to students who fall under Section 504, as well as students who receive special education services. Before we get into the details, I want us to take a step back so that we can explain the overall purpose of these provisions. The law here gets pretty complicated, but I think it all makes more sense if we keep in mind the overall purpose. As we have learned, Section 504 is about preventing disability discrimination. School discipline, on the other hand, involves consequences for students, including removing privileges and even excluding them from the school environment. When it comes to students with disabilities, we need to ensure we are complying with the purpose of Section 504. We want to make sure that we are not imposing consequences on students for things that are actually related to their disability. On its face, removing students for things related to their disability sounds like disability discrimination. What I'm about to talk through are the complicated procedures the schools are required to follow for students with disabilities when they face exclusion from school. The first concept we're going to talk about is called a change in placement. The services that a student receives through their Section 504 plan are considered their placement. As we have learned through this webinar, placement decisions are supposed to be made by the Section 504 team. When students receive an out-of-school suspension, they are not receiving their Section 504 services. The law says that at some point, those suspensions are actually causing what's called a change in placement. The law considers exclusion from school for more than 10 days in one school year to be a change in placement. When there is a disciplinary change in placement, a specific type of meeting happens called a manifestation determination review, or an MDR. If a student is suspended for 10 days or less, the law does not consider it a change in placement, and the student can be disciplined like any other student. So this part of the law requires math. Let's work through an example. Jay is a student with a Section 504 plan. He was given an out-of-school suspension for 3 days in September. Is an MDR needed? No. Jay is then suspended out of school for another 5 days in October. Is an MDR needed? No. At this point, we're only at 8 days. We have 5 plus 3. Jay is then suspended out of school for 2 days in November. Is an MDR needed? Still no. At that point, we're only at 10 days and we need more than 10 days. Jay is then suspended out of school for 3 days in January. Is an MDR needed? Yes. At that point, we're at 12 days of out of school suspension. Once you hit those 11 or more days of out of school suspension in a school year, An MDR is held for every suspension for the rest of the school year. So if Jay then gets a 2-day suspension in February, there's another MDR. If he gets a 1-day suspension in March, there's another MDR. This can mean that the team is meeting quite frequently. Each MDR must be held within 10 school days of the suspension. This can be quite challenging for families because it means that there's not a lot of time to prepare. The MDR has to take place before any further discipline can happen, such as a long-term suspension, which is more than 10 days at a time. The goal of the MDR is to determine whether the problem behavior was a manifestation of the student's disability. Here are some very important tips for parents and legal guardians. Anytime the student is suspended, the parent and legal guardian will want to request and keep a copy of the discipline referral suspension notice. Often these are not sent home with students and need to be requested. Make sure you request copies and look them over in detail. Keep careful track of suspension days throughout the school year to make sure that these meetings are happening as they should. It may make sense to keep a separate list somewhere where you can easily see it, on the fridge, in your calendar, on a note in your phone. During a manifestation determination review meeting, the Section 504 team must consider 3 questions. 1, was the conduct in question caused by the student's disability? 2, did the conduct have a direct or substantial relationship to the student's disability? And 3, was the conduct the direct result of the school district's failure to implement the Section 504 plan? If the answer to all 3 of these questions is no, the conduct is not considered a manifestation, and the student can be disciplined like any other student. If the answer to any of these 3 questions is yes, the conduct is a manifestation and the student must immediately return to school and not receive further discipline for that behavior. Additionally, the school must complete a functional behavioral assessment, FBA, and a behavioral intervention plan, BIP. We will discuss these in detail in the coming slides. These meetings are challenging. It's an emergency meeting scheduled after a student has gotten suspended. Tensions are high, and the questions are hard. Unless a therapist or medical professional is in the room, no one's really qualified to answer the first 2 questions. Question 3 is not a question that schools are inclined to answer as yes. So it is important to know whether the school is following the student Section 504 plan, and especially the student's behavioral intervention plan if they have one. If not, the answer to question 3 could be yes. The MDR process is not about whether the student knows right from wrong. That is not one of the questions that is asked, and it's not a useful question. For instance, a student with intermittent explosive disorder knows that hitting is wrong, but that does not mean that hitting another student when triggered isn't a manifestation of that student's disability. There are a lot of concerning phrases the school staff use during these meetings, and they need to be redirected. They are things like, the student should know better, or the student's a good kid when they want to be. What we have learned over the years is that underlying these comments and sentiments, often school staff are fearful that if a student's conduct is found to be a manifestation, it means that the student gets away with their bad behavior. There is a desire for students to have their punishment. But that's not what this is about. Acknowledging that there is a relationship between the conduct and the disability means that we know that traditional consequences are not going to make a difference for this student. Instead, we need to change the behavior through interventions that will prevent it in the future. Sending the student home for a few days may give the teacher a break, but it is not changing what things look like when the student returns. How would you prepare for an MDR? It's important to have the right people in the room, or at least their input. Invite service providers to attend. If they can't, have them write a letter about the connection between the disability and the conduct. Review the student's history and records. Have similar behaviors happened before? Is there a pattern to the behavior? Does the student's Section 504 plan mention this behavior? Is it included on the behavioral intervention plan? Bring information about the student's disability. Not all of the Section 504 team members may fully understand it. Consider not having the student attend this meeting. Section 504 meetings can already be pretty negative. These meetings, MDRs, they are the worst. In order to show that it is a manifestation, you're generally having to talk about all the things the student does poorly and how it's connected to their disability. This is rough stuff to hear for a student. Also, no one is allowed to dispute the school's version of events in this meeting. We have to take them as true for the purpose of the MDR, which can be incredibly frustrating to a student if they feel that the school has it wrong or they did not do the behavior. Another thing we sometimes see when the student is in the room is that the school staff will use it as an opportunity to direct questions at the student about how they can do things differently, or just blame the student. It is awful for the student and unproductive. Please remember, it is critical to go into these meetings prepared. We are big fans of functional behavioral assessments, FBAs. As I mentioned on a previous slide, if a manifestation is found at the MDR, an FBA is required. The purpose of this assessment is to determine why the misconduct occurs. We can't fix the behavior unless we know why it's happening. Behaviors are a method of communication. We need to figure out what the student is communicating through the behaviors. Not all behaviors have the same function. For instance, let's say Jay is throwing papers across the room during math class. There may be many reasons for this. Jay may be trying to get the attention of his peers. Jay may be trying to get out of his math assignment because it's too hard. Jay may actually be bored because the work is too easy. Jay may be trying to get his teacher's attention. How we would respond to this behavior if it is because the work is too hard is different than how we would respond if he's doing it because he just wants attention from his peers. Unfortunately, the law does not spell out exactly what an FBA should look like. Here are best practices for an FBA. The first step is identifying specifically what the problem behavior is. Second, there are observations done to collect data about the behavior. Ideally, these are conducted by people who do not work with the student every day. There are interviews of the student, family, and school staff. The evaluator and team determine the antecedents and consequences surrounding the behavior. Antecedents are what occurs right before the behavior. For an example, an antecedent for Jay may be that he is given an independent math assignment. Consequences are what happens right after the behavior. For example, a consequence for Jay may be that his peers throw the paper back at him and they laugh. Finally, the function of the behavior is hypothesized. The great thing about FBAs is that they do not require an MDR in order to receive one. A parent or legal guardian can and should request an FBA if there are problematic behaviors happening with the student. The FBA is then used to create or revise the student's behavioral intervention plan. We use what we learned from the FBA about the function of the behavior to create the behavioral intervention plan. What the team wants to do is carefully craft interventions that address the function of the behavior so that we reduce the likelihood of the behavior in the future. This can be done through a variety of means: altering the environment, minimizing triggers, giving the student alternative strategies, identifying meaningful incentives or rewards, changing the response of adults. Interventions should serve the same function as the problematic behavior. For instance, if Jay's behavior was caused by a desire for attention from peers, we may want interventions that allow him to have interactions with peers without engaging in negative behavior. If the function of his behavior is escaping challenging math tasks, we may have interventions that better scaffold his math work, where he can do more of it without frustration, and then get more hands-on support when it reaches the challenging level. BIPs should be reviewed frequently, generally every 6 weeks. Data is collected around the problematic behavior, and then the team revises the BIP based on the data. If a student with a Section 504 plan is getting suspended, the parent or legal guardian should request an FBA and a BIP, ideally before it even gets to the point of needing an MDR. We've included some ideas of interventions that may be on a BIP. Inform the student one-on-one about the expectations of an activity at the beginning of the activity. Use a calm tone when an issue arises and avoid engaging in verbal debates with the student. Direct instruction in social skills. Provide student with choice of activity. Use first-then language when presenting tasks. Allow student to use a pass to come to a trusted staff member when upset. The possibilities are endless and should be individualized to that student and the function of their behavior. Notice something important about these interventions. They are focused on what the school is supposed to do differently, not the student. The idea is to have the school staff modify the environment for the student to enable the student to reduce the behavior. Now that we understand about Section 504 plans, we will turn to the grievance process under Section 504. There are two main options for a grievance under Section 504: a school district's internal process, or the Office for Civil Rights, OCR, in the U.S. Department of Education. We will start by reviewing the school district process within CMS. All school districts are required to have a grievance process, but the makeup of these vary from district to district. We're going to review Charlotte-Mecklenburg Schools process in some detail to give you a sense of what it looks like. You should always check the school district's Section 504 handbook for the most up-to-date grievance procedures, including CMS's. It is important to know that you do not have to go through the school district's process. It is optional. You can instead go straight to the Office for Civil Rights if desired. The CMS grievance process is broken into levels. It is designed to try to resolve a dispute at the school level. If that is unsuccessful, it moves up to district level staff. You will see as we go through this that we have underlined the timelines. The first step of initiating their grievance procedure is reporting concerns to the school's principal within 20 school days of the violation or disagreement. At this point, the Section 504 department wants things to remain at the school level and will direct a legal guardian back to the school's principal. The next step is for the school principal to schedule a meeting within 10 school days to discuss the situation and try to determine a resolution. If the parent or legal guardian rejects the proposed resolution, they must contact the Section 504 department and submit the CMS Section 504 grievance form within 20 school days of meeting with the principal. This form can be found on the CMS website. As with any complaint form, you want to be as detailed as possible when laying out what the concerns are and attaching any written documentation you may have. If the school principal does not respond to the initial report or concern within 10 school days, the complaint may automatically be elevated to the CMS grievance procedure, level 2. At level 2, the Section 504 department will investigate the grievance and attempt to resolve the complaint. The investigation process will be completed within what they call a reasonable amount of time after they receive the complaint. After, the Section 504 department will notify the principal, learning community superintendent, and legal guardian of the findings. This and the proposed resolution will be provided to the parent or legal guardian in writing. If the parent or legal guardian rejects the proposed resolution, the legal guardian may request an impartial hearing. This request for a hearing must be made within 10 calendar days of the date of the response to the Section 504 department. The formal hearing will be held before an impartial hearing officer. The parent and legal guardian has the following rights: to request all relevant records and materials in advance of the hearing, receive professional assistance at the hearing at their own expense. This could be hiring a lawyer or having an advocate or medical professional or anyone else with information beneficial to the hearing. If hiring a lawyer, the parent or legal guardian must notify the CMS Section 504 department immediately. present evidence, and call or cross-examine witnesses. The hearing officer must issue a written decision within 10 business days of the hearing. If the legal guardian does not agree with the decision, they can request a review of the due process hearing decision by contacting the Section 504 department within 10 calendar days of the hearing officer's decision. They can seek further legal action, such as filing in court, or they can file a complaint with OCR. Let's talk about the OCR alternative. You may also choose to file an OCR complaint instead of going through the school district's internal grievance process. The Office for Civil Rights in the U.S. Department of Education is the federal agency responsible for enforcing Section 504. Anyone may file a complaint with OCR, either for themselves or on behalf of another. It is very important to know that you cannot do both the school district grievance procedure and file at OCR at the same time. OCR will not review any complaints currently under review with the district grievance process. Generally, an OCR complaint must be filed within 180 calendar days of the alleged discrimination. So parents or legal guardians cannot wait too long if they want to take action on a concern. If the issue went through the district grievance process first, the OCR complaint must be filed within 60 calendar days of its conclusion. OCR has a discrimination complaint form that you can fill out on their website. Alternatively, you can write a letter with all of the required components and send it in. We've included here the OCR website. This is an excellent resource. It includes an overview of Section 504, policy guidance on disability discrimination, frequently asked questions, and the complaint form. The regional office for OCR for Charlotte is in Washington, D.C. You can see their phone number and email address here. We have also included some helpful CMS resources. This includes their brochure, the Section 504 handbook, and also the Section 504 grievance procedures. We hope that the information provided today has been helpful. If you believe you may need legal representation related to a Section 504 special education, let me go back, sorry about that, or a school discipline issue, you can contact our team at gethelp@cfcrights.org or call us at 704-943-9609. For court-involved youth, members of the Child and Family Team or a student juvenile defense attorney can make a referral for our education navigation services by emailing elp@cfcrights.org or by calling 704-943-9611. Lastly, we have included here some helpful resources for you, some websites. Also be sure to check out the handouts for this webinar. We hope this was helpful. Thank you so much.